And whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started. Welcome, everybody, live from Hawaii. This is Omar Serrato with the Tilted Lawyer Podcast. And should I be doing a live stream right now on vacation? No, I shouldn't. But I have a small window of peace and quiet, and I'm going to take advantage of it because I don't have anything to do for the next couple of hours. And so I decided I'm going to just do a live stream because I saw this wild clip yesterday regarding a judge being confronted with an ex-parte communication, an illegal ex-parte communication in the middle of a very convoluted case involving important people. And rather than dealing with it the way that any other judge would have dealt with it, in my experience, this guy decided to just throw the attorney in jail. It was wild. Now, I'll tell you what. The defense attorney is not actually going to go to jail. He's not, well, yet anyway. He has filed an appeal. My understanding is the way that they handle these matters in Georgia is when you file an appeal, they will stay any amount of incarceration pending the results of the appeal. And from the looks of it and the legalities of everything that happened, I think that this judge is going to be in a lot of trouble. I got to tell you, I've practiced in California my entire career. I have had the privilege of practicing in jurisdictions where the judges were pretty above board in their dealings, specifically with regard to ex-parte communications in all of the criminal trials, the jury trials that I've ever tried. Judges have always been extremely careful to not engage in ex-parte communications with either side for fear of mistrial, because it's a big deal. It's a big no-no. You cannot have a communication with one lawyer and a state's witness or a witness in general without the other attorney present, or at least them knowing that it's going on. Now, I mean, you could waive being there because maybe it's not a big deal. Maybe they're talking about something that's not going to affect the case and you just don't care because it's like, I don't know, court reporter fees or something. But this attorney didn't do that. He learned about it after the fact. And when he confronted the judge with it, he wanted to discuss the ex-parte communication. And rather than doing that, this judge was starting to get really hot under the collar. And he proceeded to hold this guy in contempt of court and have him incarcerated and put on the big show where the bailiff came and had the guy stripped down from his suit and put him in cuffs and escorted him away. And there was this big to-do about, hey, this is an ongoing trial. I demand if you're going to put me in custody for weekends that I'm in the same cell with my client, because he and I talk all the time and I need to prepare for this case. It's an ongoing trial. It's been weeks long at this point. And so it was wild. Never, ever in my career have I ever encountered anything remotely like this. So here we are with all of this. And gosh, especially in criminal trials, though, I've had judges like flat out say, hey, pull us into chambers before the start of proceedings. It was unavoidable. I just want to let you know this happened. There was this ex-parte communication. This is exactly what we talked about. The reporter was there. Here's the transcript of anything. If you want to review the entire thing before we proceed, I'm welcome to do that. But they'll go above and beyond to make sure that it's not affecting anything or causing a mistrial. This effing judge, not only was he not addressing the issue, but he was threatening to incarcerate the criminal defense attorney. Not only about the ex parte communication is that a grounds for mistrial, but I think the judge made or the attorney made an objection to denying his right to counsel, which is absolutely true. That is an appealable issue. I would think if you're the prosecution, you would not want defense counsel incarcerated, because if there's a mistrial, provided there was a conviction, I mean, that's going to get reversed on appeal by a pretty good percentage. And so I don't think that the prosecutor necessarily wanted what happened to happen. Matter of fact, you kind of see her backtracking and trying to take measures with the court to make sure that the defense counsel could be there to continue to represent his client in trial, because she wanted to avoid the mistrial. But we're going to watch this clip together. In all the years that I've practiced law, in all of the jury trials that I've ever tried, I've never seen anything like this. Let's watch it together because it's wild. Let me make sure I'm sharing my screen with you. I should get rid of I hope there's not an echo. Hey folks, if there's an echo, please just let me know. I'm trying to multitask in the comments. Sharing my screen. Here we go. All right. So get a load of this. We're going to watch this together, and I'm going to share my thoughts.
Okay, Mr. Steele, would you take the podium, please, sir?
Judge is out of breath.
All right. All right. Mr. Steele, before...
I should offer this caveat that I know nothing about this trial. I've not watched a single day of this trial. I don't even know what the issues are on this trial. The only reason I'm covering it is because of this exchange right here that we're about to listen to. Let me stop interrupting.
Recess. I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, I'm just.
But in order, you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information.
That question by itself, as an attorney, would have set all kinds of red flags off for me. What do you mean I'm going to tell you who I got it from? No, I don't. I'm basing this off of information and belief. I'll share with you the substance. And once you have the substance, we could all have a discussion about it. How I got the information is irrelevant. The fact that it happened is highly relevant and is part and parcel to whether or not this is going to result in a mistrial. So let us get over that issue, because I'm not disclosing it. He had no authority to order that attorney to disclose who he got that information from for a million different reasons. But once again, I'm interrupting. Let's continue.
If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah, and that's why I raise it. It is that serious
that is not what is sacrosanct. What is sacrosanct is the ex parte communication that this judge wished to have concealed.
We should have been there, and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
And just so I know a little bit about the reasons for the ex parte, there was a witness, I think, from the state side that didn't want to testify. And so it was highly relevant, depending whatever this guy was going to say, the fact that he was not wanting to testify and was being compelled to do so, and they have this ex-parte communication to where it might not have affected the trial, it might not have been. But if it's regarding a witness that I prepped for, then I want to be there when they have the proceedings.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, tell you're
Hey, if you're going to walk across the camera, you're just going to have to come across and say hello. Nope, not even. All right. Sorry about that, folks.
you're straying off the issue.
I'm not. I'm
The
trying to
issue
reach-
is the issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you.
Okay,
you're
but
saying,
see,
you're threatening me with
the
contempt. Just
privilege
listen
would
to this.
occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you, I can't do that under the bar rule.
All right. Well, I'm going to hold you in contempt.
Get
And,
the F
you
out of
you
here.
can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you some and substance.
He just read the rule to him.
I asked you how you got it.
He just read the rule to him, word for word. And he's saying, well, that's not what I understand the rule to be. It was pretty clear. This judge is bullying this attorney. It's so transparent. And it's so shocking to me because I cannot relate to this level of misconduct on any level. I've seen some fiery exchanges between attorneys and judges, but never where one is so blatantly, transparently an act of bullying and threatening an attorney with contempt, literally trying to place them in jail because they're citing a rule and they're failing to follow this judicial order to break a professional rule of conduct. He's arguing privilege. He's arguing all these other things, whatever, fine. But that the fact that they're not even if the judge thought that was true, even if he thought it was true, the fact that he's not addressing the substance of the ex parte is problematic.
Can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have
may
an
be
idea how
wrong.
you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not
Sir,
going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
From
that
whom?
part of it.
From whom?
Well, I'd like to get the substance first, and then we can
Okay,
talk
well, then you'll be in custody until then, because
Well, then-
because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me
There is no rule. There is no rule of court. There is no rule of professional conduct that I'm aware of that compels a lawyer to reveal the source of information for a violation of court procedure or decorum. It appears to me on its face to be an illegal judicial order subject to a misconduct strike from perhaps the state bar over there. And I don't know, maybe I'm speaking out of turn, but there is nothing legally that this judge can do to compel that defense attorney's identifying the source of information of an illegal thing. Now you're going into constitutional protections, constitutional violations, whistleblower laws. There's all there's probably a dozen different things that you're breaking by forcing an attorney to reveal the source of information that led to them discovering misconduct on the part of a court that will lead to a mistrial. So the fact that it was live streamed, the fact that this is such a high profile case, even though I know nothing about it, that's just because I had zero interest in it up until now. But yeah, the fact that the judge is doing this with all of these eyes on him lets me know how brazen he is in his belief that he's safe. That's the only way that I can interpret his behavior.
That somebody parroted that information to you. So,
But you're assuming something because I told you already.
well, then,
I
other than
answer
if
that
you were
on the
if you were sitting,
attorney-client.
unless you were sitting in there with a recorder or Miss Love or Miss Hilton or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor,
And if that person gave you that information or shared that information with you, she probably violated privilege.
well, let me tell you two things. One, I don't know how that was a privileged communication. It shouldn't have
Well,
been.
it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways,
The judge is invoking a privilege on behalf of an attorney who hasn't invoked it herself, and he's invoking it incorrectly, while at the same time ignoring the privilege invoked by this defense attorney while he's trying to compel him to reveal his source. That is, you can't make that shit up. That's crazy. That's crazy.
I'm not going to have
When I got
I'm
this
not gonna have any
information,
further- I'm not going to have any further conversation
Well-
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside of her.
Jules, the answer to that question is pretty much, I think the judge. How could you interpret that other than the judge wants to discipline the source of that information some kind of way? Because you're going to hear him say over and over, it was either this person or that person or the court reporter or that person. That's the only people it could have been. I want to know who it was. That is an act of an attempt to try to intimidate whoever it was that leaked that information, because he's going to try to do his best in his judicial capacity to silence that person or punish them somehow, probably in a way that he's been doing for a really long time.
That's
All right.
really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your I'm going to deny your
Upon me.
motion. I'm going to deny your motion.
I
for
understand that you
mistrial.
spoke with a
And when-
witness outside our presence.
And whenever, yes, I had an ex parte conversation, which is
and you-
appropriate.
And you influenced the witness based upon information
Oh.
belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing
Okay.
happened bad, that's fine. But you're
All right.
acting like, tell me who it is and don't talk about the substance.
Moja, even if he was eavesdropping, that's not illegal. If he's eavesdropping, he could just walk into the room. Then it's not an ex-party communication, and then we're all good. So what difference does it make if he's eavesdropping? If he's right there close enough to be eavesdropping, then invite him into chambers. What are we doing this ex-party shit for? I apologize, folks. I missed the button.
Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, we can, that's for another day.
But why?
Okay,
Why
that's for
did we
another
exclude
day.
in the first place? I didn't know about this stuff.
That's for another day. So,
I raised it as soon as we found out about it.
well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic
Steele,
reversal.
Mr.
Mhm.
Steele,
But you're acting like it's
Mr. Steele,
private.
that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not.
He needs to cite the law that he's making that statement from, because I guarantee you that that's not a real law. That is not a rule. You do not have the ability to compel the source of information of wrongdoing in a trial if it's reversible error, which it 100% is in this case. This judge is wrong. He's misstating the law, and he's doing it from the bench, and he's doing it in a very public capacity. And the fact that this attorney has maintained his cool for this long. And, you know, I applaud him for standing up to this guy. I mean, he full on took on this incarceration, this contempt charge in the name of standing up for his clients. There's not a lot of attorneys that would do that. Most attorneys I know, when confronted with, you're either going to shut up or you're going to go to jail, they just STF you 100%. But this guy is standing up for what he believes in. If I was in front of this judge, I'm not sure how I would react, but I imagine I would have maybe lost my cool and started yelling back and forth between myself and the judge, because he's just blatantly wrong. He doesn't know the law. Either he doesn't know the law or he's just outright misstating the law because he knows that he's been caught doing something really bad that is going to be brought up at a later date from in a potential judicial misconduct hearing. Who knows? But there's no effing way that is the rule. And if it is, he needs to cite to it. There's no chance. I think he's wrong on that. He was wrong on how the contempt process works. He was wrong. He just doesn't know the law. It's bizarre to me. This judge does not know the law.
Not supposed to have communication with a witness who's been sworn. You know, that I'm not telling you, I'm just saying, if you read I'm assuming you read it. That's what it says. And you did it supposedly.
The state wishes to be heard.
You said it supposedly.
Does the state
what
wish
I'm
to be
trying to
heard?
get to is why
Wow.
that happened outside of presence, and I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it, and then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind
And
anything.
you can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless
There's a reason why he's saying that without citing the rule. This defense attorney is citing various rules of conduct as it pertains to the state of Georgia. And then this guy is saying, well, you can't hide behind the rule because, and then he sounds like he's about to go into some kind of a rule that's justifying his possession. And then he just says, I know for a fact he got this from somebody around here, which is to say that he's full of shit.
you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information.
It's 100% false.
Party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
I'll
entitled to the-
that's
But that- isn't that the
least
issue?
that needs to be told. But
But
state,
then-
do you
but
have
right
anything-
We
now,
will be told. I
we
don't think
don't
that's
know
saying.
Mr. Steele.
why we were excluded from that.
Mr.
And I
Steele,
want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right on the
Just stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1,
you've
paragraph
already said that. You've already
the
said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam, Ms. Love.
That is crazy. And Red Hot Maverick, thank you so much for finding the channel. I'm glad you found us. I hope you subscribe and join the family. We're happy to have you. But this judge is just beyond. I've never encountered anything like this in practice. I'm very lucky to be able to say that. Most of the judges that I know, I see them all the time. There's some cases that I'm going to be covering in the next couple of days that are going to expose judicial conduct of monumental proportions. And I'm happy to report, for the most part, that the judges that I normally practice with are really smart. They know the law most of the time as well as I do, if not better than I do. And they try their best to maintain some kind of system where there's balance on both sides. But this guy looks like a 12-year-old that just got caught, and he's trying to find a way to present an argument to his mom so that he doesn't get in trouble because he knows that it's coming. Oh, and it's coming. But he doubles down on it. He triples down on it. It's just bizarre. I don't understand why he's so brazen to act this way.
know I said this previously.
Yes, sir.
But we are not accepting any proffer
Oh,
from
gosh,
Ms.
okay,
Love.
excuse me.
Good for him.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte
Doesn't matter.
conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present.
She has the right to.
That the defendants.
She has the right to request an ex parte communication, but she doesn't have the right to conceal that communication from opposing counsel. The fact that she requested a court reporter be present is immaterial if defense counsel didn't waive his presence and didn't know about the communication to begin with. So she's wrong. But this judge is not going to rule that way because he knows or should know that he's in the wrong.
Did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court.
Yeah, and that might be the case. That might be the case. It might have absolutely zero effect on the relevant issues for the trial. It doesn't change the fact that defense counsel had a right to know that it was happening and had the right to either waive their presence or be present at whatever that communication was on the off chance that it might turn from a civil contempt proceeding to something that affects the trial. And that's the problem.
Directive. The state read the case that Mr. Steele cited. It does not stand for the proposition. He asserts that it does. And regarding
explain that to me like I'm 5.
Legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen.
I swear to God, if I was practicing in this courtroom, I would feel like I'm in the Twilight Zone right now. What the F is she talking about? That she's concerned that somebody leaked an illegal ex parte communication. That's the big concern here. Am I missing something or am I in kangaroo court? What jurisdiction is this? What country are we in? Jesus.
And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information.
I would be so hot around the collar if I was in this courtroom, in this judge, in this attorney's position. I would be so pissed off. Like, get the shit out of your mouth. What are you trying to say? What kind of nonsense? First of all, she's stumbling over words because she knows that that's not the rule. She knows that's not the rule. She knows it's not the law, but this is what the judge is going with. And she's being very careful with what she says, but I feel like she's trying to alter what she knows is true and trying to play off of the judge's concern, his unfounded concern that there's some legality in who is the person that leaked that there was an illegal communication in the middle of a trial. It's so beyond bizarre. I can't even relate to this level of unprofessionalism. I've been involved in a lot of unprofessional cases that were conducted by a judge before, but to this level, I would feel like I was I feel like I was on another planet. Like, what are we even doing? What did I go to law school for? What is this shit?
Was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last.
I can't with this lady. I cannot. I cannot. Hey, Rob, are you talking about the fact that they just dropped a motion to recuse this judge? Is that the news that you're talking about? Because if that's what it is, I'm aware of that. And I wanted to go over that. I didn't want to read it word for word. I know a lot of people are going to do that, but I'm aware that there is a motion to recuse this judge. And I don't know where they're going to go with it because I'm kind of nervous about who's in charge over here in this jurisdiction. But I guess we'll see. I think I accidentally screwed something up with the playback. Oh, I sure did. Yeah, we were at 12:27. I'm going to pause that so that I can bring it back up on screen so that you guys can continue to listen in.
For everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice.
Right, I think I'm going to
ask that the court.
I think that how could you not start following this trial at this point with all of this nonsense going on? And thank you so much for the $2. Yeah, 100%. I think I'm going to have to go back and see what is going on with this case amongst all of the other cases that we have to cover. And this attorney is getting on my nerves. She's saying nothing. She's been speaking, I feel like, for 10 minutes and not said anything.
Strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
Waste of time. Can we move on?
Regarding Rule 1.6.
Oh my God.
Your Honor, we read 1.6 as we're standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers.
It doesn't matter, lady. It really doesn't. Hey, K-Rob says, Georgia Supreme Court weighed in. There is info on the content on the ex-party hearing. Judge and DA are going to, why is it hidden from my screen? Oh, be in trouble. Oh, I agree. They have to be at this point, right? look, it's undeniable that this is judicial misconduct. There's any first year lawyer out there that just passed the bar could look at this and know that something is wrong. They might not be able to know exactly why it's wrong, but this is judicial misconduct of the most brazen form that I've ever seen. With this many eyes on the case, and this is what this judge is going with. And look, whatever this, he's letting the state prosecutor, she's up here giving a word salad, and nobody knows that nothing that she says is relevant or even altogether correct. The judge is letting her run with it. However, the other defense attorney, whom he held in contempt, was citing relevant statutes and laws that actually applies, where he was actually correct, and he's bullying him and talking over him and ordering him, compelling him via judicial order to reveal the sources of how he found out about this misconduct. Of course, this is going to be a lot of people are going to be in trouble. This judge, I'd be shocked if he's still on the bench at the close of 2024. Let's continue.
Or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Iron Rabbit, thank you so much for the 5. Yeah, I think I'm gonna watch a lot of people's opinions on this, Judge. Like I said, I knew nothing about this case until now, and but yeah, I gotta learn more. WTF?
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained
Okay.
from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has 2 attorneys.
Okay. Yeah, he does. But
The court, now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself.
What?
That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously.
My apologies, folks. That what was I thought that was the judge speaking for a minute. I didn't realize it was the co-defense counsel. I rescind my what.
Previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
all right. So,
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things.
So once again, I'm unfamiliar with this trial. is their co-defendants, who is a Miss Stillwell. But the fact that her representation is also calling for a mistrial. I'm just going to say this. There's no chance at this point, unless something happens that clears all of this up, that this trial that I know nothing about does not end in a mistrial. There's just way too much going on. Such a waste of time.
Things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple of days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor,
I just got to say this. This trial being held in the Deep South, there is a rich history going back 300 years of severe corruption on the judicial level. And to have this blatant display of judicial misconduct in a trial of this magnitude, where it took 10 months just to seat a jury, lending itself to the mistrial of this, whatever stage they are at the trial, a massive waste of time and resources is just astounding to me.
I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred, where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, same thing. You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the statements.
All right,
Good afternoon, Your Honor. Carson Matthews, on behalf of Mr. Mark Williams.
okay,
We are also adopting all the arguments that have been made.
all right, sir.
Still by attorney. With that, charged by attorney Philip Weinstein. We also we were here before the time, and when the court did come out, we were not made aware that there had even been an communication that was had, that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got started. We believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice if there was something that was going on, even beforehand. I thought that would have been it.
Yeah, and that's exactly the point. It's not that whatever was disclosed, it's not that even the judge had bad intentions of somehow giving the upper hand to the state's case in the communication. It's just the simple fact that it happened without notifying opposing counsel and giving them the opportunity to waive their appearance if they felt it was irrelevant, or to be there just in case. You don't get to make that call. You're the judge. You call balls and strikes. You do not get to represent the defendant. You do not get to legally represent either side. Legal strategy is not up to you. You don't get to determine what's relevant or what's not, specifically in a jury trial when you're just there to marshal the evidence for a jury. And everything that all the defense attorneys are saying is 100% legit. I don't know, honestly, what that prosecution, what the state's attorney was trying to get at. It was a whole lot of word salad, basically mimicking the concerns of the judge, which were illegal in its foundation. But everything that all of these defense attorneys are saying is 100% above board, stone cold law from the statutes that were written out for the state of Georgia.
But nonetheless, Your Honor, I'm asking the court for mistrial. I believe it's perfectly clear under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. D. Williams? All right, thank you, madam. Motion's denied. Mr. Gardner? Okay.
So if this happened to me, what would my reaction to it be? I would be, when I'm in the courtroom, I'm pretty cool with just about everybody. I have good relationships with the bailiff, with the court reporters, with opposing counsel, with my own clients, with everybody, with the judges normally. I'm usually there not to make anybody's judge or job harder. But there has been occasions where there have been fundamental disagreements on the law where I've gotten really hot under my collar and I've had to make very emotional arguments, I guess you would say, arguments that I wouldn't normally make unless I absolutely had to. In this case, I cannot foresee myself in that position. Look, if you're going to hold me in contempt, then I'm going to give you a reason to hold me in contempt. I'm not saying that I would lose my shit. I'm just saying that I would probably have a few choice words and I would want to set the record clear. I would probably recite word for word the statutes that this guy was trying to cite and make sure that the record is clear of the laws on which I was arguing, that make clear that I have no duty whatsoever and cannot be compelled to reveal the source of my information that alerted me to the fact that there was an illegal ex-parte communication, for one. And for two, I would not be bullied by a judge on the threat of contempt by refusing to address the ex-parte communication in general because I refuse to give up the source of my information, which is legally irrelevant. I cannot imagine there's any scenario where I'm not getting arrested for contempt. I'm sure. Luckily, I will say this. I've never encountered such a blatant disregard for the law as what I'm witnessing right now. And so there's no need for me to have ever reacted that way. And the judges and the lawyers with which I practice, for the most part, all of the judges are really good in terms of keeping things fair. I have not, like I said, I've just never witnessed this level of blatant judicial misconduct. And I rue the day for when I have to face that kind of misconduct, because it requires a certain position. And that position, imagine the burden of an attorney where you have to advocate for your client, and you know the judge is wrong on the law, and the way that they're conducting themselves in this trial is grounds for a mistrial, and they are ignoring all of those laws to begin with. Imagine the position that you are forced to put yourself in. In order to effectively advocate for your client, you must be arrested for contempt. That's the position that this defense attorney was placed in. And good on him that he stood his ground with this judge. And it looks like, by all appearances, by the shockwaves that reverberated from this meteor hitting the legal world, that he's going to be okay. And this is 100% resulting in a mistrial. Oh, I pressed the wrong button. My apologies.
All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in.
All right, at that point, I might lose my shit. And for the last time, who told you? None of your effing business. Judge, why don't you tell me how you had a illegal communication with opposing counsel when I had the right to be there without notifying me that it was happening? That's the most relevant question that you should be asking. And how I got the information is none of your business. Contempt me then. Oh boy, I'm supposed to be on vacation, folks. My beverage of choice right now is a rum and Coke. I'm not a big fan of rum. I don't have in my room anyway, access to the greatest, my normal beverage of choice. But this rum and Coke is delightful. K-Reb says, to sum it up, in the ex-party meeting, the ADA subpoenaed perjury or suborned perjury, and the judge said nothing. That I'm fascinated by. If that's true, if the district attorney suborned perjury and it was inherent within an illegal ex-party communication, I would want to know that if I'm the defense attorney. If I'm within 10 meters of this case, I don't want to know that happened. I don't want to have the ability to have been present. I would never have waived my presence at that communication. I'm so thrown back by how all of this is being handled.
Custody. And once he clears the area, we'll go ahead and get started. Yeah, we're going to continue. I'm not caught nothing. I'm not going to participate in the trial without the Steele. You don't have that luxury at this point in time, sir. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't. Without the court addressing the issue, we believe this jury. Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you. You are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again? Respectfully, I will not. I cannot. Sir, you have to. Well, you're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir.
He literally said, you don't get to extort the court. I don't get to ask about the substance of an illegal ex-party communication, judge, because you want to compel the source of how I found out that you were doing something illegal. That's what you're calling extortion nowadays? Oh my goodness gracious. I don't understand a lot of things. I don't understand a lot of things, but that comment might have sent me over the edge. If I'm getting arrested anyway, I guess I might as well get my money's worth. We might just make this a Better Call Saul moment. What do you call it? Oh, I can't even comprehend the audacity of that statement. I'm getting upset right now as I'm listening to this judge.
Sir, yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that.
If there is any accuracy to some of the information that we.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that.
The fact that he keeps using that word sacrosanct, I'm not even sure that he knows what sacrosanct means. The judge's chambers is supposed to be sacrosanct. It's supposed to be a sanctimony of justice. It's supposed to be a position where you walk into chambers with opposing counsel, never without opposing counsel, and go about the business of discussing the case so that nobody else gets to hear, so that we get the relevant issues dealt with in a timely manner. The fact that he's saying it's sacrosanct, that you are aware of an illegal ex parte communication, and that's what he's deeming as sacrosanct, is just so beyond logic to me. I am shocked at this judge's conduct and his choice of words. I just don't get it. I don't know who this judge is. I don't know about this case. I don't know about this jurisdiction. All I know is I have very strong opinions about what's going on here, and none of it is good.
You're glossing over that in its entirety. No, it's not, sir. Sir, that's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Yeah, get the fuck out of here. I apologize for cursing.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of
Okay, all right.
I don't even want to be a lawyer no more. I quit. You know what, man? Oh, if I was practicing in Georgia, I don't even want to practice anymore. F this. I mean, you go to law school and they teach you nothing about how to be an attorney. They teach you bullshit law that you need to know to pass the bar. And then you get into practice and they're so hell-bent on teaching you the rules of professional conduct, and the attorneys are held to such a high standard. And then to watch a judge just basically shit on all of it haphazardly, in the face of like multiple defense attorneys telling him that he's wrong because he is afraid that he got caught. What are we doing? Also, you're in a position. Look, he's sitting there in a position as a judge that is in charge of a very high profile trial, and he's behaving this way. He's literally there. He's made it. He's got good money. He's got good benefits. He's, in a position of power, and he's abusing it like this so openly, not even being smart about it. It's like you're listening to a seventh grade locker room fight between two idiots. That's what I could liken this to. I'm so beyond appalled by what's going on here. I might as well finish it because this attorney's about to say something.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Well, take it under advisement then, asshole. Red Hot Maverick says Steele was sentenced to 10 weekends in jail. Yeah, that's not going to go forward. So my understanding of that is he filed an appeal. Whatever incarceration that he was sentenced to is going to be stayed pending the results of the appeal. There's no scenario in which which I would imagine that the appeal is not going to be upheld, because I don't think that this judge understood the rules of contempt the way that he was explaining it to Mr. Steele's defense counsel. Literally later that night, they had his defense counsel make an appearance and have to explain to this judge the rules of what happens when you directly contempt somebody. This judge literally said, no, he has no right to due process. The hearing is right now. I am the witness. I am all of it. And so he has no right to call witnesses. He has no right to confront witnesses. He has no right to do anything. It all happens right in the moment. So, okay, but this was a direct contempt. Well, yes, it was. Well, then, yes, he does. And you are now a witness, and this must go before a different judge who is not you, because you clearly don't know the law, and we're going to have to need some objective pair of eyes to take a look into what's going on. So this attorney is not in jail right now, as far as I know. The breaking news is that there has been a motion filed to recuse this judge, which I don't know if it's going to be granted or not. I'm skeptical about the entire state of Georgia at this point. I have no knowledge of how law works in Georgia. I'm a practicing attorney in the state of California. And I don't know what's going to happen with the motion to recuse. It's usually really hard to recuse a judge. You have to have a really good reason. What would be a good reason? Well, how about the judge just doesn't know the law and has a personal vendetta against the defense attorneys in this case? And upon challenging the fact that there was an illegal ex parte communication inherent within the trial, he bullied this attorney, held him in contempt, threatened him with 10 weekends of incarceration, and threatened the defendant in this case with having his counsel represent him at an ongoing trial that's been going on for weeks. That's a pretty good reason. And at that point, what do? I mean, I'm pretty sure, we've already kind of established there's multiple grounds for mistrial in this case, but do we just start all over? Do we start all over at this point? I don't know. There's a lot going on. Like I said, I don't know a whole lot about this case. I know that there's bullshit going on. And I am flabbergasted by what happened here at this hearing. Absolutely flabbergasted. Oh boy. Laura Needy says, weekend incarceration. What is that like? Some Breakfast Club style punishment, but for lawyers? No, incarceration sucks. I'll tell you what, every time that I've ever gone, so I've worked for a good portion of of my career as a criminal defense attorney. And one of the things that you have to do when you're representing criminal defendants is visit them while they're in jail. And when you do that, it is such a striking thing to walk through the walls of a prison, sit in a cell basically with your defendant, and you're like separated by these walls, like a plexiglass, whatever. You can't even give them like a pen to sign documents unless it's like yay thin. But the weight of walking through county, I can't imagine a more torturous place for an attorney who's in the midst of a trial to spend the weekend in than county jail. I've heard stories that state prison is a lot more, well, it's not as good as county jail. There's a lot more leeway in county jail, I guess. There's also the benefit of 2-for-1 credits. But in the middle of a trial that's weeks long, where you're normally working through the weekend to prepare for the day's witnesses, for whatever, for a lot of things, to have to sit there and just stare at the wall all day, Jesus Christ, I just can't imagine. I can't imagine. I don't know where we go from here. K-Rob says that the Georgia Supreme Court stayed the jail time and gave Steele a supersede bond. Yeah, so my understanding with that is that they're going to, whatever incarceration he's going to get is stayed until they figure out the merits of this claim or whatever. So he's not actually in jail right now. He's able to continue and proceed with trial. But what a absolute shit show that was. So yeah, I'm spending my vacation talking about this stuff, and I might be a little bit lubricated. I'm maybe 3 rum and cokes deep. I'm over here with my family in Hawaii. We should lighten the mood a little bit. My kids were here earlier, and one of them was venturing into the oceans of Hawaii and was playing in the rocks and slipped in the water and cut their hand on like this sharp rock or whatever. It's like this little paper cut. And from the screams that I heard when she came back into the house, you would have thought that, it was like this murderous thing. And so we had to give her like a tourniquet and a bandage, a princess Band-Aid, and of course. That's what I've been doing. My vacation so far has been, it's a family vacation. And if you've ever been on a family vacation, it's sort of like vacation, but not really, because you're just kind of there watching your kids. So my entire vacation has been devoted basically towards chaperoning my 4 and 5-year-old to various beaches and pools and water slides and things of that nature. I got 2 sets of families here. I got my in-laws and I got my, what's the word for my family? Not outer laws. You have your in-laws and my laws. 2 sets of family. Imagine how many of them have volunteered to babysit so that myself and my wife could have a night out. 0, double zero. And so I was telling my wife, man, we need a vacation from our vacation. I should get this off the screen, huh? There we go. So yeah, I think that I wanted to go live just to talk about it because I had this momentary time to do so, to talk about what's going on in Georgia. Lots of shenanigans. But I think, and I'm not at my normal studio where I could turn the lights purple, the purple haze lights. But I think we're going to do a little bit of some family law after dark because I haven't done it in a while. I kind of miss it. I miss Dominic because he would do this thing with the lights and he would have like this little intro to it, and I would make fun of him for looking at me funny and all of those things. I'm adjusting as Dominic has moved on to greener pastures with a full-time job with full-on benefits. I've had to make adjustments. I also have this case that I am going to be doing probably when I get back to California. about a number of, well, CPS and the judges in dependency court over in the state of Illinois may be corrupt, and we're going to expose all of it probably next week. I have some special guests in mind. They're going to be coming on. Ileana Clone Rosa is going to be joining us pretty soon. She was going to join us today. We tried to schedule something for today, but it just didn't work out. So next week, when I'm back in my normal studio, we'll do all of that. But let's do some Family Law After Dark. I'm going to take 90 seconds, and I will be right back. For those of you that want to stick